I want to introduce the first of our afternoon speakers. Is Martin Rochwerg, who's well known to you. He's spoken frequently at this and other conferences. Marty is a senior partner in the law firm of Goodman & Carr. He practices Canadian and international tax and estate planning. He graduated from Osgoode Hall Law School and was called to the bar in 1974. He's been the special lecturer of estate planning at Osgoode Hall Law School since 1980, and he's been a seminar instructor for the Faculty of Law, U of T, and an instructor at the Bar Admission course. He's a past chair of the Ontario Trust and Estate Section and an immediate past chair of the Estate Planning Council of Toronto. He's an active member of STEP and also belongs to the American College of Trust and Estate Council and is a member of its International Estate Planning Committee. He is the editor, he's one of the editors of Goodman on Estate Planning. And he's going to speak to us this afternoon on cross-border estate planning. So please join me in welcoming Marty.
Good afternoon. Upside down. Good afternoon. I can't prepare you for the whole afternoon, but I'll try and prepare you for the next half hour. Some of you would have been here last year, the first time this program was offered, and just to remind you, the topic that I was given at that time was creative cross-border estate planning. And I had a bit of a problem with that when Elena proposed it, and I said, you know, I'm a right-handed brain person, and this is a little tough. You want me to be creative? And she said, well, you know, have a go at it. So she continued to do that. I noticed this year, you'll notice the word creative is gone. It's just cross-border estate planning. We're nearing the end of the 20th century, and some commentators say we're leaving it in a more dangerous fashion than when we came into it. And so a number of us, of course, are trying to emphasize our more compelling qualities. Some of you have no doubt read Tuesdays with Maury. And so I decided that I too would want to exhibit some positive attributes. And you know, so I choose one every day. So today I thought sharing would be a good one. I mean, we're doing this, we're going to share some information. But I have to give you a fair warning. I just came back from the dentist. Okay? So, the paper is in your materials at tab 6, and at some point you'll want to have a look at two of the appendices. You'll notice that the second page of both appendices is the same, and you've got it's actually the second page of Appendix 1. In preparing for today, I went to see what I had attached to my paper, and I have the second page twice to tab 2. So I'm only going to be talking about the second appendix and not the first appendix. The areas that I'd like to cover with you, there's been a lot of activity in the cross-border area in the last year. And what I'd like to cover with you, first of all, are some of the items that flow out of the 1999 federal budget. We're a little bit wiser today about it than we were on February 16th. The other thing I'd like to do with you is highlight some issues relating to U.S. estate tax and some of the cross-border ramifications there. Let me just begin with the federal budget and draw to your attention that there are basically two types of changes that were proposed in the federal budget in the cross-border area. One of them was divided into two sections, and it was basically how foreign income was going to be taxed where Canadian residents had been involved in establishing whatever that foreign trust or other entity may be. The first one, to give you a bit of description on that, and it's generally referred to as new foreign investment fund rules, and I'll just give you a very brief reference and do it in the context of what Simon Thompson said to the Canadian Tax Foundation about 2 months ago. He was speaking on this, and he's the one at Department of Finance, who's responsible for overseeing the drafting of the legislation and making some of the policy decisions. Here's what he calls his brief description of the new rules as they will relate to foreign investment funds, otherwise known as FIFs. The proposed approach for FIFs provides for an annual allocation of a FIF's undistributed income to a Canadian unit holder. If insufficient information is available for a unit holder to adopt this approach, the unit holder is to be taxed on an annual basis on any increases in the fair market value of the unit holder's interest in the FIF, and that's generally referred to as mark-to-market. There's a fair bit there, but I think the part that might interest you most as you kind of contemplate where our governments are going, not just Canada but U.S. as well, in terms of some of the cross-border things. I think it's worth just hearing a paragraph or two out of his response to the question. People lose money when they invest as well as make money. I'm sure this audience would undoubtedly agree with me, based on my experience. What does he have to say about losses and how will they be treated? And just to read you a particular paragraph, and it goes like this. If a taxpayer's interest in a FIF is subject to the mark-to-market regime, any gains of the taxpayer in respect of the FIF will be subject to 100%, not 75% income inclusion. The FIF interest would not be capital property. Given this income treatment, and given that there is no opportunity for taxpayers to selectively dispose of FIF interests covered by the mark-to-market regime, it has been argued that FIF losses should not be ring-fenced, that meaning treating them as they can only be deductible against other similar kinds of income. The counter-argument is that the absence of ring-fencing allows taxpayers a potential advantage that was not available under the existing regime. Moreover, from a Revenue Canada perspective, and I have no idea how he would know anything about what Revenue Canada thinks, because I don't think he's ever worked there. Moreover, from a Revenue Canada perspective, there may be concerns that taxpayers may selectively reveal interests of FIFs in which they have losses while concealing interests in which they have gains. All of these considerations will be taken into account in finalizing recommendations in this regard. So, ladies and gentlemen, our government does not trust us. But that is important to know. We now have as well proposed rules that are really quite remarkable. And they are to the effect that the government has kind of given up, notwithstanding all the new forms in the foreign reporting area. The government has pretty much given up trying to come up with an equitable way to tax offshore income. And the government's concern is they've had a lot of trouble, and some of this has been because of some creative planning done in Canada, that it's hard to figure out whether or not there's a Canadian who's going to benefit under some of these foreign regimes. So the concern being, we know we want to tax Canadians, but what if there's some kind of offshore entity, i.e. a trust, as an example, that it's very hard to decipher who is going to eventually be entitled to that income. Well, in the February 16th budget, it was determined that if a Canadian contributed at any time to a non-resident trust, then irrespective of whoever is going to benefit from it, if there is undistributed income, then that undistributed income, if it is not taxed in some significant way in a foreign jurisdiction, it is going to be taxed in Canada. There would be a foreign tax credit to the extent one would have paid foreign taxes, but if one went to all the trouble of setting something up offshore, why would one want to pay foreign taxes? So the residence of the beneficiaries is now going to become irrelevant. In addition, the Canadian contributor is going to become jointly liable. As to when these rules are to take effect, and please appreciate we don't have any draft legislation to help guide us in this area. It's to take effect in 2001 if you stopped contributing on budget day, But otherwise, in respect of post-budget contributions, it will take effect within the next 5 weeks. As proposed, this rule will apply to any kind of contribution, meaning both transfers and loans of property. So care has to be taken where there are trusts that have been set up by some grandparent or whatever who never immigrated to Canada, but for whatever reason was able to amass some wealth outside the country. And if they set that up, you don't want to be making a loan to this particular trust, because it may, as if a Canadian is doing that, in some way change the rules that will apply to that foreign trust. Now, some exceptions were proposed. One of those exceptions, which, without reading you the detail about what Simon had to say about it, there's some reneging going on, but there's supposed to be an exception for U.S. trusts that are subject to U.S. tax. And of course, one of the issues was, why limit it to U.S. trusts? Why shouldn't it apply to trusts in other jurisdictions with some relative modicum of tax? The answer that came back is, well, we're not worrying about the other jurisdictions because we're not that sure about the U.S. anymore. And they're concerned that planning could be done through the U.S. and in effect it would be a U.S. trust, it would be subject to U.S. tax, but it wouldn't be paying enough tax from a Canadian perspective. As well, immigration trusts would be an exception, but there's an important change coming there, which we saw for the first time in the December 23rd legislation, which was discussed this morning, which is immigration trusts now have to be created before arrival in Canada to get the treatment that otherwise is generally regarded as belonging to an immigration trust. Another exception is where the trust is benefiting disabled or children of divorced parents if the trust and the beneficiaries are in the same jurisdiction. So if parents divorce and the children go off with one of the parents to another jurisdiction, then these rules will not apply. Also, certain foreign charitable trusts are going to be exempted. And when the question was asked, well, what are certain foreign charitable trusts, the answer that came back was bona fide. I think a lot of questions come out of this, and we'll have to watch for this as finance, and these rules are being promised before the end of the year, but I think most people are quite skeptical as to whether that target will be reached. What if the distributed income, in a lot of trusts, some income's accumulated, but other income's distributed? What if that distributed income can be traceable to the contribution made by a Canadian, so that the income that's being accumulated is pretty clearly from somebody else? What kind of an exception will exist for that? What about contributions by others to the trust? If the Canadian only contributed 10% of the trust, are these rules still going to apply to a 100% situation? And then really, perhaps at the crux of all this, is it considered to be avoidance under our Income Tax Act just because you happen to have foreign beneficiaries? I mean, is that a policy rule that, notwithstanding a lot of things in Canadian society that one would have thought really promote emigration, and then we have an emigration tax that, and okay, what am I talking about? What promotes emigration? I don't know how some of you reacted to the media attention, which a little bit like Star Magazine or something like that, to the fact that some doctors actually work hard enough and are skilled enough to earn large amounts of funds and presumably pay their taxes and pay their expenses. And clearly Canadian society has a big problem with that. I think that promotes emigration. But that's okay, because we now have a new emigration tax as of October 2nd. So that might deal with it. But now are we being told if our children, which so many of them are taking their education and their software engineering skills outside the country, is that now considered tax avoidance as well, and our trusts are going to be subject to certain penalties. On top of all that, we have a new rule, something that we probably considered something incredibly basic to our tax regime, that we tax income, we don't tax capital. Capital's already been taxed somewhere. So the issue becomes how is income, or how are payments, let me say, that are paid to Canadian beneficiaries out of a non-resident trust going to be regarded. As of December 23rd, we got a bit of a new concept as to what's income and what's capital. But I don't think any of us anticipated that at the very time that we were getting new definitions for the purposes of our Tax Act, it would change once again less than 2 months later on February 16th, and we would be told that accumulated income that had become capital for trust law purposes was going to be reopened and treated as income and the first nature of a distribution from a foreign trust. The residence of the contributor is going to be irrelevant. It doesn't matter that this was settled offshore with offshore assets. Now we have a Canadian who's going to be receiving payments. Can they receive capital payments? What is the extent of that going to be? Once again, we're met with the fact these rules are retroactive. It doesn't matter that these trusts were set up a long time ago, whether testamentary or otherwise. These rules, we are told, are going to apply retroactively to those trusts. Now, you do have the opportunity before the end of this year, and you should study it closely, to distribute these trusts. You might want your Canadian to go offshore in any event, but why not? Okay, you've got large accumulations of income held offshore. They've been taxed in the relevant home jurisdiction of that particular trust. The income has been accumulated. The rules change on January 1. So pay those amounts out to your Canadian beneficiaries, and then go on and deal with them as you see fit. Unfortunately, again, we're in a position where we're being promised rules, but we don't have them in hand. I've made a couple of references to December 23rd. I don't know about the rest of you, but legislation that comes out on December 23rd, I do not spend a lot of time with before January 1. So whatever may come out in the holiday season this year, you're going to have to anticipate it, because we're talking about rules that take effect on January 1. Let me switch topics and go to the estate tax and cross-border issue, which is one of the items I've been asked to deal with. I think one of the first points is really how many levels of tax does one want to pay? I think we'll all agree one seems plenty enough at 50% tax rates. Of course, you know why we don't have an estate tax in Canada. After our income tax, what's the point of having an estate tax? So you pay your one level of tax, and you don't want to pay a second one. In the paper, on the one of the very last points on page 35, there's an example of something that really concerned the Joint Committee of the CBA and the CICA, and it was really the issue of that where there are credits available within the Canada-US system, they don't always work at the same time, and they force you to accelerate a level of tax if one wants to ensure you only pay one level of tax. So for instance, US estate tax is very difficult for a Canadian to defer. We have this concept of qualified domestic trust, QDOT, under the US system, but it's very, very unworkable. And with that regard, very often estate tax is going to be exigible on the first to die of a husband and wife, and here I'm thinking of generally Canadian citizens and residents. And the issue is really going to be, if one defers the Canadian capital gains tax, which otherwise will be offset against the U.S. estate tax, will there still be an offset? And the answer at the moment is there will not be an offset, and one in effect has to avoid the deferral and accelerate the level of tax to be able to get the offset. And needless to say, they're not always going to fully eliminate the tax, and in the end it may well lead to a higher rate of tax. Another comment I'd like to make is, notwithstanding that I think there's been a fair bit of attention paid to what constitutes U.S. situs property and the terrible difficulty where Canadians end up investing in public companies that are incorporated, let's say, in the U.S. I mean, that subjects the owner to U.S. estate tax. We have all these financial advisors out there. Don't take this personally, Joel. We have all these financial advisors out there, all purporting to add extra value to their clients' circumstances. So not only do they get them the best return, but they give them all kinds of free advice to go along with it. And yet, time and time again, we see allocations of assets that the lawyers and the accountants have very little control over, because the financial advisors want the money and they want as little interference as they can get from other advisors. So the end result is you find at the end of the day there's this portfolio of U.S. assets. There was a holding company. It had investment assets. Why weren't the U.S. investment assets done there? The company didn't die. The shareholder died. They're not there. You look for them in some trust entity that quotes didn't die. They're not there. Why are the U.S. investments sitting in the deceased's name? What can you do afterwards? Very little. And yet we're still coming across it on a constant basis. Another situation, this will be the last one I'll deal with, is we have a growing number of U.S. citizens who are working here in Canada. Some of them come with their spouses if they think they're, and we're living in a new age of e-commerce and jet travel and all these things. So some come with spouses, and then that's interesting, because then you have a Canadian spouse and you can qualify for certain Canadian rollovers, and some of this is discussed on page 31 of the paper, and you've got benefits there. But then there are others who become Canadian residents, and their spouses do not become Canadian residents. They're quite happy, thank you, with the school system wherever they are, and people can fly home the same way as we've got a lot of Canadians who spend their working week in New York. There's a lot of the reverse going on. So what are we going to do for these U.S. citizens that come here, either with or without a spouse? You have some real problems. The U.S. is very, very tough on its U.S. citizens where they have foreign trusts. And from a U.S. perspective, a Canadian trust is a foreign trust. And there are numerous occasions where it makes sense to establish a trust in Canada for the benefit of these people, but we have to bear in mind these particular U.S. rules. You're fine if you distribute the income. Your income is, you get your proper credits, the tax is paid on an annual basis. But if you accumulate, notwithstanding that you're paying high rates of tax here in Canada, the U.S. is very wary of accumulating income in offshore trusts for its U.S. citizens. And as a result, when distributions are actually made, they have a whole series of rules, and they were aggravated by changes in 1995. Throwback rules, penalty interest rules, and you can get situations which Michelle was confirmed to us earlier this week in a circumstance where the overall tax is greater than the amount of the distribution. Not a good result. So I guess the warning is, if you've got some U.S. citizens and their trusts that either are resident in Canada from the outset, or they became resident in Canada because your clients are the trustees, We think that's resident in Canada. The U.S. rules on what constitutes a foreign trust versus an American trust is a little different, and it has to be consulted. But be very wary if you're accumulating income, particularly in a testamentary trust where you may think it's beneficial from a Canadian perspective to be continuing to build up the assets in the testamentary trust. I think you have to be very, very careful in that situation. I think that's everything I have to say. Bye for now. Want my toothbrush?
He offered me the toothbrush but took away the microphone. Thank you very much, Marty. That's a very good treatment of a very complex topic, and I've just been flipping through the paper, and I think it's got some good information in it. Marty and Joel Cuperfain, our next speaker, will be available during the break to answer questions, since we're running out of time in terms of allowing the speakers as much time as possible to make their presentation. Our next speaker is Joel Cuperfain. He's a lawyer. He's a regional consultant with Manulife Financial's Tax and Estate Planning Group in Toronto. He has a BA cum laude in economics from Brandeis and received his LLB with honors from U of T. He was called to the bar in 1992, and he has spent several years in private practice before he joined Manulife Financial. Joel has really adds value to those of you who are looking for insurance product for your clients. I'm a frequent user of Joel's expertise, and I've always found it invaluable. He's a frequent speaker and writer on topics relating to tax and estate planning, and is here to speak to us about the use of insurance in estate planning, some of the issues and tips and traps that you should look to avoid.
Thank you, and good afternoon. Bear with me for just a moment. I appear to be slightly out of focus, through no fault of my own. Thank you. The paper this afternoon is actually divided into 4 different parts, dealing with taxation of life insurance, various products that are available in the Canadian marketplace today, taxation of life insurance, the stop-loss rules, variations of trusts, and disability insurance. I'm going to focus my comments only on the area of taxation of insurance and the stop-loss rules. Traditionally, life insurance has been used in personal estate planning for such things as income replacement, paying of final expenses, tax payments, estate equalization, charitable giving. In the business context, it's been used for such things as funding of shareholders' agreements, key person protection, business loan protection. And if you speak to an insurance agent, you will typically be told that the world of life insurance can be divided into 2 distinct categories, and that is term insurance and permanent insurance. And the insurance agent will tell you that term insurance does one of 2 different things. It either solves a temporary problem, or it will solve a permanent problem temporarily. Permanent insurance, in contrast, is going to be used to solve a permanent problem, and is what we would focus on in terms of overall estate planning. Well, that sounds real interesting, but real boring, if I may say so. The question you might be asking is, that's very nice, but since when would you consider life insurance to be an innovative financial product? For those at the back who can't read the caption, this says, having spotted the approaching Revenue Canada auditor, Rodney hurried the family into the tax shelter. After listening to some of the other presentations earlier today, it becomes clear that there are limited tax planning opportunities available in this country, and limited tax-sheltered investments that are still available for our clients. Life insurance is unique. It is a tax shelter to some extent, and it will continue to be a tax shelter under our Canadian tax system, precisely because life insurance is unique in that it offers elements of both protection and investment. And as long as the protection element of the contract predominates based on the rules set out in the Income Tax Act and the regulations, then the contract will be protected from accrual taxation. And whenever I say accrual taxation, you can spell it either way you want. It works both ways. From a tax planning perspective, life insurance can be divided into 2 different categories, not the term and the permanent that I talked about earlier, but rather exempt and non-exempt. When we talk about exempt life insurance, that's exempt from the interest accrual rules, you have a minimum amount of funds that could go into the insurance contract to keep the policy alive. There is a ceiling beyond which this policy looks more like an investment vehicle rather than a protection vehicle. But what is of interest from an estate planning perspective and from a financial planning perspective is this window, this tax-protected or tax-exempt window of opportunity within which funds can accumulate within the insurance contract on a tax-sheltered basis. The Reader's Digest condensed version of the taxation of life insurance would run something like the following. Premiums for life insurance, not deductible, subject to a few limited exceptions, the most significant being the deduction for collateral insurance under paragraph 21E.2, and as elaborated by Revenue Canada in Interpretation Bulletin IT 309R2. The growth of the insurance policy is tax-sheltered. Dispositions of the policy on an inter vivos basis would be taxable, but the death benefit would be tax-free. You could sort of think of it as the inverse or reverse of the RRSP, where it's tax-deductible amounts going in, tax-sheltered growth, taxable on the way out. The insurance contract is the flip side. After-tax dollars going in, tax-sheltered accumulation within the policy, and tax-free dollars coming out at the back end. So what we have with life insurance, we have the ability to overfund a life insurance policy, take advantage of the tax-sheltered environment within the policy. An added benefit in the personal context is that the insurance contract enjoys protection for creditor protection purposes as well, provided that a preferred beneficiary has been named or a beneficiary has been designated irrevocably under the policy. And as we say, the tax-free proceeds in the event of death. I should also mention in the corporate context that the additional benefit is the credit to the capital dividend account, and I'll be talking more about that in a few moments in terms of the stop-loss rules. But just a point to bear in mind when you're looking at corporations with investment dollars within the corporation, that the insurance contract does provide the corporate vehicle with an opportunity to obtain tax-free growth, tax-free proceeds, and through the capital dividend account, the opportunity to take those dollars out of the corporation through the CDA all on a tax-free basis. And that's a fairly unique financial vehicle. I can't think of any other investment that would give you tax-free growth, tax-free proceeds, and the ability to extract, those proceeds from the corporation on a tax-free basis other than the insurance contract. I'm going to take about 30 seconds just to mention the type of insurance contract that your clients may be speaking to you about as insurance agents bring proposals to the client, and that's the modern universal life insurance policy. The universal life policy is what is often referred to as an unbundled insurance contract, where you can actually see the various components of the policy. You can see the deposits going in, you can see how the investments are growing, you can see where funds are being taken from the policy to fund mortality costs, to fund the various administrative expenses, but everything is very visible, very transparent, and very attractive to the client. Universal Life provides a very flexible investment vehicle and insurance protection vehicle. It's flexible in terms of the deposits, where there is great flexibility in terms of how much actually is deposited to the contract. Flexibility in terms of coverage, where you may have multiple lives, several lives covered under a single policy. Flexibility in terms of the death benefit, where the death benefit may be an original amount plus the investment under the policy. It may be a level amount. It could be an indexed increasing amount. Great deal of flexibility as to how you want to structure it, when the proceeds are payable on a first death, on a last death, and a great deal of flexibility in terms of the investments available within the policies as well. And those investment flexibilities will include things like a daily savings type account, simple and compound guaranteed investment accounts, various portfolio accounts, and a variety of different index accounts, or balanced portfolio accounts of various types. That is the condensed version on the products available and the taxation of life insurance. I encourage you to take a look at the paper for a more detailed review. And I want to shift gears significantly and focus on the stop-loss rules and the changes to the treatment of capital dividend account and the former ability to use capital dividend account to create a loss in the estate and to offset capital gains arising on the deemed disposition at death. What I want to do is take a walkthrough of the rules, take a look originally how the rules operated, or how the planning operated prior to the changes in the rules back in 1995, see what the rules did, see the grandfathering opportunities that are still available, and then take a look at any other planning opportunities that the clients can still take advantage of. So I want to walk through quickly a little case study as to how the rules operated back in the good old days of pre-April 26, 1995. And what we have is we have two shareholders, Mr. Tweedledee and Mr. Tweedledum, and they are co-owners of a company we call D. Dum Co. D. Dumco has a fair market value of $2 million. Each of the shareholders have $1 million worth of value. We're going to assume nominal adjusted cost base, nominal paid up capital, and the corporation has $1 million worth of life insurance on each of the two individuals, and we're going to kill off Mr. Tweedledee. We're going to take a look at the tax implications to Tweedledee, Tweedledum, Tweedledee's estate, and to the corporation. So first we're going to take a look at the implications to the corporation, D. Dumco. Again, this is under the old rules that we're looking at. And D. Dumco, as the beneficiary of this insurance policy, would have received $1 million worth of proceeds. The proceeds would have been received tax-free. We would assume that the policy has a nominal adjusted cost basis. The credit to the capital dividend account would be the insurance proceeds minus the ACB of the policy. We'll assume nominal ACB, so the full $1 million credits the corporation's capital dividend account, and the corporation has the tax-free dollars available. Looking at Tweedledee, first of all, Tweedledee has died. Tweedledee has the deemed disposition at death and 75% capital gain, assuming a 50% tax rate. He, at first instance, has a tax liability of $375,000. We're going to use the insurance proceeds to redeem the shares from Tweedledee's estate. $1 million goes out. The deemed dividend is $1 million. The full amount of the $1 million is declared to be a tax-free capital dividend, and the estate receives the proceeds, $1 million, fully tax-free. We also have to take a look at the capital gains implications to the estate. The estate has disposed of the shares, which it had a cost base of $1 million. Its proceeds are $1 million, but the full amount of those proceeds, $1 million, was also deemed dividend. So the $1 million is subtracted to determine the adjusted proceeds for capital gains purposes. And the estate is deemed to have received $0 for capital gains purposes. And since its cost base was $1 million, it would realize a $1 million capital loss. Normally that capital loss would be trapped within the estate, but under subsection 164(6), as long as the capital loss is realized within the first taxation year of the estate, it can be carried back to the terminal return of the deceased. And lo and behold, our $1 million capital loss exactly offsets the $1 million capital gain arising on the deemed disposition at death. And Mr. Tweedledee is very happy, except for the fact that he's very Tweedle-dead at this time, because his tax liability is exactly $0. What's happened to his tax liability? Well, he's essentially bequeathed it to Mr. Tweedledum. At the beginning of this exercise, Mr. Tweedledum owned $1 million worth of shares of a corporation, and he had an accrued capital gain of $1 million. At the end of this exercise, he now owns 100% of the company. The company is still worth the original $2 million, so Mr. Tweedledee has effectively transferred $1 million worth of value to Tweedledum. And if Tweedledum turned around and disposed of his shares, he'd realize a $2 million capital gain. So the taxes that have been saved by Tweedledee have effectively been transferred to Tweedledum. So this was obviously a very attractive mechanism of structuring buy-sell arrangements and indeed of structuring transfer of control of family businesses from one generation to the next with a view to totally deferring the tax liability to the next generation and the next and the next. And it's a very significant and attractive tax deferral opportunity. And life was considered to be very good. And then came April 26, 1995. The picture behind me, by the way, that's a graphic of the insurance agent with the major closing on April 27, 1995, and that agent's reaction to the rule changes. April 26, 1995, there was a technical bill, and the technical bill extended the existing stop-loss rules that had formerly applied only in the corporate context, extending those to the individual context as well, and simply said that if an individual, including an estate, realized a capital loss, the amount of that loss, capital loss in the disposition of shares, the amount of that loss would be reduced by the total of all tax-free capital dividends received by the individual, subject only to a de minimis rule holding the shares for more than 365 days and not owning more than 5% of the shares of any class. And the rule as originally announced was to apply to all dispositions of shares subsequent to April 26, 1995. What this meant in terms of our little example with Mr. Tweedledee and Tweedledum is that the capital loss in the estate based on the original rules would have been reduced to $0. Tweedledee's estate would have received $1 million worth of proceeds tax-free, but Mr. Tweedledee would still face the tax liability arising on the deemed disposition at death because there would be no capital loss. Now, the other important point to realize is that even though Tweedledee has paid tax at the time of his death, there is no increase in the adjusted cost base of Tweedledum's shares. So Tweedledum would effectively be paying tax on the same gain that Tweedledee had already paid the tax on. That looks a lot to me like double taxation, in that both parties are going to be paying tax on the same gain. Of course, the Income Tax Act has its own definition of double taxation. Double taxation is what happens when one taxpayer pays tax twice on the same thing. When two taxpayers pay tax on the same thing, that's not double taxation, that's revenue enhancement. And that's considered legitimate by Revenue Canada, Department of Finance. So we have a very substantive change to the rules, can no longer defer the tax liability arising on the deemed disposition at death. This was a rule change that significantly impacted existing business arrangements. And as we'll see in a few moments, these are rules which, at least in my own humble opinion, were not considered to be, would not be considered to be fair or equitable all around. And the rule was basically seen as the death of, I like that. My secretary worked very hard to superimpose Mr. Martin's face on the Grim Reaper there. The rules were basically seen as the death of the corporate insured redemption strategy, and to a very large extent, especially in the popular press, the rules were more or less seen as the death of corporate-owned insurance. And you would have seen articles in the paper around about the time that these rules were digested, that all of a sudden corporate-owned insurance had become taxable, or indeed life insurance had become taxable. Nothing's further from the truth, and we'll see that with proper planning, the tax liability can be significantly minimized, the double tax risk can be eliminated, and there are still some very attractive planning opportunities that are still available. Finance does have a heart, and to some extent, perhaps a limited extent, but does have a heart, at least in terms of these rules. There's also the possibility, and it's only a rumor, that the insurance industry itself may have been involved in lobbying of the Department of Finance. Only a rumor. I don't know if that's true or not. I find it hard to believe, but it perhaps is possible. In any event, the rules were modified. Two areas of relief for all taxpayers. The first one being a taxable dividend rule, which I'm not going to go into for purposes of the talk, but it is addressed in the paper itself. And another rule referred to as the 25% rule, of the 25% solution, which I will speak about in a few moments. There was also some very attractive, very significant grandfathering relief. To a large extent, the grandfathering relief, in my view, once again, unprecedentedly generous in a variety of circumstances. Okay, so what do we do about it? Well, let's first of all take a look at the grandfathering rules. Just give this guy a fellow to come across. There you go. Okay. There are two different areas of grandfathering relief: pre-existing insurance, pre-existing agreements. You could qualify under either one of the two rules. The pre-existing agreement rule essentially says, very simple, if shares are redeemed pursuant to an agreement in writing that was executed prior to April 27, 1995, the old rules apply. All the things that we saw originally with the old rules with Tweedledee and Tweedledum, where the tax liability to Tweedledee could be eliminated using corporate-owned insurance and the credit to the capital dividend account, that would continue to apply as long as the shares are redeemed pursuant to an agreement in writing entered into prior to April 27, 95. The issues and opportunities here are significant. The issue, or significant issue, is that changes to a pre-April 27, 1995 agreement could taint your grandfathered status. And Revenue Canada takes a very conservative view as to what sort of changes to an agreement would constitute a new agreement, a novation of the original agreement. If you have a novation, you lose your grandfathered status. I think that the lesson to be learned for people in this room, the significant lesson, is if a client does have a pre-April 27, 1995 agreement, it doesn't mean that there will never be changes to that agreement, but it certainly will be critical that the clients understand what the implications of a change to a pre-April 27, 1995 agreement will be. And the consequence could well be loss of grandfathering relief. So a word to the wise, a word of caution: if the clients do have grandfathered agreements, consider funding the agreement. You don't have to have had the insurance in force as of April 26, 95 to take advantage of this rule. You can take advantage of it now as long as the agreement was there, but changes to the agreement could result in a loss of grandfathering. The second area of relief, and the area that will ultimately be of more long-term value, recognizing that there may well have to be changes to pre-April 27, 95 agreements, the more attractive area of grandfathering relief is the pre-existing insurance rule. In order to qualify under this particular rule, a corporation, any corporation within the corporate group, must have been a beneficiary of a life insurance policy on April 26, 1995, and it must be reasonable to conclude that one of the main purposes of that insurance policy was to fund in whole or in part the redemption of shares on the death of the shareholder. As long as you can satisfy the beneficiary test, being the corporation being a beneficiary on April 26, 95, and satisfy the reasonability test, then you are always grandfathered. It may well be that the policy that was in force on April 26, 1995 subsequently lapsed, and a new insurance policy can be put in place now. As long as you satisfied this rule on the snapshot date, April 26, 1995, you will always be grandfathered. There are a lot of intricacies dealing with these rules and a lot of trips and traps which are set out in the paper. And I would once again commend you to take a look at the paper. The other point to mention in terms of these rules is if you had had a corporate, go back to Tweedledee and Tweedledum, if Tweedledee and Tweedledum had had, say, $100,000 worth of insurance coverage in force on April 26, 1995, even though they didn't have sufficient insurance on the two lives to fund all of the redemption of all of their shares, they still would have been grandfathered because if they satisfy that reasonability test, if the purpose of the policy was to fund a redemption in whole or in part. It doesn't matter if you were underinsured on the relevant date, as long as the insurance existed, grandfathering relief will be available. So the lessons here are to review client lists, see if grandfathering relief is available, and if the relief is available, consider having the clients fully fund the agreements to take fullest advantage of the tax deferral opportunity that's available. Well, that's all well and good if you happen to be grandfathered. The more significant question on a go-forward basis is, what do you do if you're not grandfathered? Well, the first comment to make is that there is an opportunity involving spousal rollovers. And that is that if you trace through, once again, Mr. Tweedledee and Mr. Tweedledum, and in their circumstance, if on the death of Tweedledee, rather than having the shares redeemed immediately, Tweedledee died and his shares were transferred to Mrs. Tweedledee, and the shares were redeemed from Mrs. Tweedledee, stop loss would not apply. The shares would transfer to Mrs. Tweedledee on a rollover basis, subject to vesting, and that's addressed in the paper. Once again, you have to make sure that the shares actually vest indefeasibly in the surviving spouse. But as long as you have indefeasible vesting, the shares transfer at cost base. The shares can be redeemed from the surviving spouse. The dividend is received tax-free. There is no capital gain. There is no capital loss, and stop loss doesn't apply. Again, this is set out in a little bit more detail in the paper. The problem with taking advantage of the roll and redeem strategy is it's pretty hard to know with certainty which of two spouses is going to die first. The solution to that particular problem is that the insurance policy could be taken out on a joint first-to-die basis. That is, in the event that Mrs. Tweedledee dies, the corporation will receive the $1 million of insurance proceeds. If Mr. Tweedledee dies, the corporation receives the $1 million worth of proceeds. Either death, the proceeds will be available. If they should be lucky enough to both die simultaneously, the policy pays twice, so there's an added benefit. But taking advantage of a spousal rollover and then redeeming from a surviving spouse is certainly one opportunity that should be looked at. This, by the way, is not a reason to get married, but it is certainly a benefit to be achieved if you happen to die leaving a surviving spouse. Okay, the other area of relief is something that has come to be known as the 25% solution. And the best way to explain the 25% solution is to look at an example. I should mention, once again, there are a lot of trips and traps on the 25% solution, some of which are discussed in the paper in more detail. And in the limited time available, I'm going to keep it to a fairly plain vanilla example. The one comment I do want to make is that the 25% solution only applies in the estate's context, and it only applies in the first taxation year of the estate. It's not a relieving rule that's available to everybody. It's only applicable in the estate's context in the first tax year. So I want to take a look at an example as to how the 25% solution works. And the example I have is we have father and son who are in business together. OPCO has a fair market value of $3 million. Dad has done an estate freeze a couple of years ago. His shares are worth $2 million. He's got $2 million of pref shares, no cost base, once again ignoring capital gains exemption issues and so forth, which adds a bit of added level of complexity, which isn't necessary for right now. Mom is predeceased, so there is no opportunity for a spousal rollover. Dad knows that there's going to be a tax bill to be paid when he dies, and based on current rates, that tax liability would be round about 37.5%, or a total liability of about $750,000. And these shares are not grandfathered for purposes of the stop-loss rules. The 25% solution does provide the relief that is necessary to help Dad satisfy this particular tax liability. And I'm going to mention something at the front end and mention this again at the back end, because it's a subtle, well, maybe not so subtle, but often a point that's overlooked. When we look at how the 25% solution operates, the life insurance, as we're going to see, is going to do two different things. Number one, it's going to fund Dad's liability, and number two, it's going to reduce Dad's liability. And very often when people focus on the 25% solution, they see one or the other, either funding or reducing. They don't recognize that the same insurance policy is doing two separate things. We'll see how it works in just a second, but it will actually reduce Dad's liability and fund the reduced amount. Okay. As we say, the 25% solution essentially says that the stop-loss grind, the reduction in the loss, will be reduced by the lesser of the capital gain on death and the capital loss otherwise determined. Said slightly differently, the 25% solution allows you to take out capital dividend equal to 25% of the lesser of gain or loss without application of the stop-loss rules. You can take out 25% on a tax-free basis, and stop-loss will not apply. So we'll see exactly how this works and exactly what that means. It sounds a little bit confusing, I realize, and I see some quizzical looks. What we're going to have is we're going to have the operating company take out a life insurance policy on Dad in the amount of $510,000. Now, Dad's original reaction to this was, wait a second, I thought you said that my tax liability would be $750,000. Say, yes, without proper planning, the tax liability would be $750,000, but by taking advantage of this relieving rule, we can actually reduce that liability from $750,000 to $510,000. Dad dies. In the normal course, Dad is not killed by son stabbing him through the heart. Dad dies a natural death. The operating company will receive the insurance proceeds of $510,000, and OPCO is going to redeem Dad's $2 million worth of preference shares for $2 million. Doesn't have $2 million of cash. It's going to pay out $500,000 in cash, or $510,000 in cash being the amount of the insurance proceeds. The balance will go out by way of a promissory note or a stock dividend or some sort of non-cash consideration. In some fashion, and the paper describes exactly what I mean by in some fashion, the dividend will be split between a capital dividend and a taxable dividend. 25% will be capital, $500,000. 75% will be taxable. Since the capital dividend is only 25% of the $2 million, the capital gain, the capital loss, stop loss will not apply. You will end up with a full $2 million capital loss in the estate, which exactly offsets the $2 million capital gain on the deemed disposition at death. And the only liability that is payable is a taxable dividend of $1.5 million. And that taxable dividend of $1.5 million generates a tax liability of $510,000, assuming a 34% rate for dividends. So is this a good deal for Dad? Well, Dad's liability would have been 37.5% on a do-nothing basis. Simply by converting capital gain into deemed dividend, that liability can be reduced down to about 34%. But when you tack on the 25% solution on top of the reduced rate of tax applicable to dividends in any event, you can actually reduce Dad's total tax liability on death by roughly 1/3. So as I say, the insurance is doing the two different things. It is reducing the liability by roughly 1/3 and providing Dad with the dollars necessary, or Dad's estate with the dollars necessary to fully fund that liability. Again, the question would be, but for using the insurance, where would the dollars have come from to satisfy the tax liability that we know was going to arise at the time of death? So the insurance doing the double duty of reducing the liability and funding the liability. And the other point, of course, is we have redeemed Dad's shares using a combination of cash and promissory note. And this promissory note that was paid out to the estate, that's a tax-paid amount, that becomes an asset of the estate. Dad can pass that asset on to son by way of will, and son now has the opportunity to take out $1.5 million tax-free from the company by way of debt repayment. So a respectable deal for Dad, the tax reduction, a respectable deal for son, who's able to take advantage of the promissory note and receive 100% of the corporation at the time of Dad's death. Amazingly, I have actually completed my comments within the time allowed to me. The bottom line on the stop-loss rules is the corporate-owned insurance still makes a lot of sense, but things just got a little bit more complicated. That's certainly par for the course. Anytime you talk about any sort of tax planning or estate planning, complication comes with the territory, and this is one more area of complication that does have to be dealt with. With that, I thank you very much.
Thank you, Joel. That was a very impressive performance. I don't think I could have spoken more quickly myself. And I'm known to be a nonstop talker, so I was told this morning. Our last speaker before the break is Barry Corbin. Barry comes to law through a science background. He got his Bachelor of Science at U of T and then got his Master of Science as well, right? Did I read it? I didn't realize that. I've known you all these years, I didn't know that. Barry got his LLB at the University of Ottawa and got called to the bar in 1982. He is now a partner with Borden & Elliott, and he practices in the area, not surprisingly, of tax and estate planning, estate administration, and he has also branched into mediation of estate disputes and is doing a lot of innovative stuff there. He's a prolific writer. He's the editor-in-chief of the Estates, Trusts, and Pension Journal, which is a very informative journal. I'm sure a lot of you read it, and is also the founding editor of Money and Family Law. He has been on the executive committees both at the CBAO level and also on the national level, and belongs to a large number of committees and has spoken at a great number of conferences. He's going to speak to us about the Family Law Act, and he's entitled his talk 5,000 Days On. So I don't know, have you counted those days, Barry? Oh, I should have known. That's a science background. Well, 5,000 days on. Let's find out what's happened to the Family Law Act.
So much for the science background. Okay. Thank you very much, Elena. I heard Martin mention the millennium. It seems to be on everybody's lips nowadays. Everybody seems to be an expert in it. On my way over here, I passed by an HMV store, and prominently displayed in the window was a video with Don Cherry, a pair of skates, and his dog, Blue, or one of his dogs, Blue. And it said, Don Cherry on the Millennium. So I guess everybody can be an expert. I don't know, maybe it's the subtitle is Y2KO. Anyway, last year I spoke about tax planning for estates, in estates areas, and at that time I introduced it and said it was tax is always a moving target. And little did I know how right I was. I started off my paper talking all about re-URG and the significance of it, and recovering probate fees and all that. And the day I presented it, it was the day after the government had introduced legislation to introduce the estate administration tax. So I tried to pick something that's a little bit more slow-moving this time, in the hope that one day after I presented it, it might still have a little bit of value. What I thought, I don't know why it occurred to me to count up the days. I had nothing to do that day, I suppose, but I thought I would try and cover a number of the significant things that we have learned about the Family Law Act, primarily as it relates to estates practitioners, and then try and see if there are still some questions we don't have answers to, and of course may never have if the court cases don't come along at the right time, or if they amend the legislation, which don't hold your breath over that. But so I'm not saying these are the only things we know and the only things that that we don't know. But in terms of slow moving, that would certainly, the property rights under the Family Law Act would certainly qualify for that. There has been only one amendment of any consequence to the property rights since 13 and a half years ago, and not surprisingly, it was as a result of, I think, the insurance lobby, who came along and said we didn't like the fact that surviving spouses who elected in favor of equalization claims, and by the way, I'm going to assume that this is basic stuff for everybody here. You understand the fundamentals about the Family Law Act and equalization claims. But when it was first introduced, it said if the surviving spouse elects in favor of equalization, he or she will be deemed to have disclaimed entitlement to the proceeds. And along come the insurance company and say, well, wait a second, if we pay the surviving spouse on one day, and the very next day he or she claims the equalization payment, then we have to go chasing the spouse to get the money back. That can't be right, and it wasn't very long before the legislation was amended to make it apply. Interestingly enough, they said it was amended on effective July 10th, 1986, but there's actually a little tiny gap in the legislation. They forgot to deal with cases where somebody dies on July the 10th, 1986, if you go back and look at the implementing legislation. Anyway, so as far as what we know We now know more or less what property is. There's a very broad definition in the Family Law Act. It says any interest, whether present or future, vested or contingent, in real or personal property. And then it goes on to say, and there's a whole bunch of things that are very specifically included if you had any doubt as to the breadth of the definition. One thing that was decided relatively early on is that professional licenses and degrees are not property. And in fact, there was a case where what was at issue was a law degree, and the court found, before the thing got settled, yes, a law degree is property, but it's not worth anything. And I think you could all agree with me on that. From an estates practitioner's point of view, the most interesting point is that an interest in a trust is, in fact, property. And that was the Brinkos case decided whenever it was, about 10 years ago now, which is, I guess, in a way, bad news for estates practitioners. The question of what is value, the Family Law Act doesn't talk about fair market value. It says value, and why they thought that was a good idea, well, I guess they wanted to leave it flexible, but as a result, there was a ton of litigation that ensued that mightn't have been necessary if they'd chosen a more explicit term. But they settled more or less on fair value, and that's a much more elastic notion, and it's often been equated with value to owner. And whereas fair market value, and I'm going to tread in waters that I don't know anything about, and that is valuation, fair market value is sort of what would you pay for something? And that's easy enough. But fair value is what would you pay in order to have something that you already have not taken away from you, like your law degree, for example. So there is a more flexible approach in that respect, because the question of your being able to sell it doesn't matter. If it's not a transferable asset, that in itself doesn't necessarily mean that the property has no value. It might have value to you in your struggle to prevent it from being taken away. One of the questions about interest in trust that had been asked for the last 13 years, and only in the last couple of years has there been an answer, although a very unsatisfactory one, is what about a totally discretionary trust? You are a spouse who is one member of a class in an entirely discretionary trust. You might get nothing, you might get something. What's that worth? And that question perplexed lots of people, lawyers, accountants, valuators, and then along came this Sagel and Sagel decision, which found, probably wrongly, that the father in this situation, who was in the class along with his children and his grandchildren in a totally discretionary trust, he was held to have an interest in the trust. And there have been a number of articles written that suggest if all you have is an expectation that is reliant on the trustee exercising his or her discretion in your favor, that's not an interest in a trust at all. It's just an expectation. However, that didn't bother Madam Justice Ellen MacDonald. She found that this father in the particular case, since it was his marriage that had broken down, did have an interest in this trust. And how did she value it? She said, well, let's see, we got the father, kids, grandchildren. She counted up to 7. Divided the estate, the trust property by 7, and said, okay, the father, you get 1/7, leaving something to be desired in terms of the mechanics. And unfortunately, now that's the only decision that's out there that deals with the question of what happens if a spouse is a member of a class in that kind of a discretionary trust. Another more issue about value that you will have read a fair bit about, I'm sure, was this best and best decision, and that had to do with the question, how do you value a pension entitlement? And the issues were, do you simply say, what was the pension interest worth when you got married? What was it worth on valuation day, and subtract the two numbers? That's called the value-added method. Or do you apply a prorating exercise and say, well, let's look at how many years the individual was a member of the pension plan and how many years of that was the person married, and then take that fraction of the value. And the court held that the latter was a better approach than the former. Somehow in keeping with the spirit of the legislation. What is an interesting question that wasn't answered in that case, because it was a marriage breakdown scenario, was what happens if a person dies, and that's the equalization claim being made, then what was that pension worth one day before death? And that I'll come back to a little bit later in talking about valuation of life insurance. Another early issue that was litigated hard and often was, what about tax and other costs of disposition? You're holding an asset if you sold that asset and you incurred costs of disposing of it, whether it's an agent, a real estate agent in a piece of real property, or if it was a tax cost to you on selling it, couldn't you say, well, all right, I own this $100,000 property, but net after tax, it's only going to be worth $70,000 to me. Surely I don't have to account for the 30. And the cases went all over the place. And eventually the Court of Appeal came along in Sengmuller and said, here's a whole bunch of principles, and they're all listed on page 7. I'm not going to recite them, but I do want to just draw your attention to the end of number 1 there, where they talk about taking them into tax costs and other costs into account, unless the costs are so speculative that they can be safely ignored. When we're talking about income tax liability, of course, there's nothing speculative about it when you die. Well, what is it? Speculation is exactly when you're going to die, but on death, you're going to have those deemed disposition costs. You're going to have the deemed collapse of RSPs and RIFs. So there's all these things that might come into your income subject to spousal rollovers, which I won't talk about. So if the valuation day is 1 day before death, because the parties have been happily married, more or less, for a period of time, and there's an equalization claim being made on death, you look at the day before death. Well, at that moment, the tax bill isn't owing, so maybe you don't have to include them. You don't get to take them as a liability from the estate's point of view, but 2 cases have held that there's nothing speculative about taxes on death, and therefore in the scenarios in that case where it was not a marriage breakdown but a death that ended the marriage, they said, you sure go right ahead and subtract all those amounts. Now, it seems to me the same argument you might want to make. Well, suppose the marriage breaks down at a time when you're holding RSPs or RIFs or property, capital property that is appreciated in value. You know you're going to die someday. Why not say, fine, I'll just do a present value exercise and I get to deduct that in calculating my net family property calculation. I think, as I'm suggesting in the paper, the difficulty with that is we have a progressive tax structure. You can sort of take money out in dribs and drabs, and we've got tax credits and deductions, and it's possible that you will never incur that tax liability. And in fact, I've never seen a case, which doesn't mean I've looked at them all, but I've never seen a case where the argument was put forward that there are tax costs associated with RRSPs, RIFs, and capital property that's gone up in value. In a marriage breakdown scenario, it's going to be incurred eventually. Let's just do a present value exercise. But maybe that's because nobody's bothered to raise that issue. What about all these other things that come up? The costs of administration. And in fact, there was a case on that one. There were no reasons. It was just a very short endorsement where a judge said in reward that those are all costs that are proper deductions, even though they haven't been incurred because the valuation date is 1 day before death. And in that case, what was up for grabs was executor's compensation, legal fees, and disbursements payable in connection with the administration of the estate, which raises lots more questions than it answers. What about state administration tax? We have, I think the Ontario Court of Appeal said in re Yourig, it's a virtual necessity that you have to take out probate in order to effectively administer the estate. So why wouldn't you say that state administration tax is just as inevitable in the death scenario as income tax is? Funeral and burial costs, challenges to the will, all that kind of stuff. Anyway, let me talk about deductions and exclusions, which are not really problematic now, because I guess we know the answers, but the answers aren't very satisfying. Conrad Black's brother, Montague Black, we have him to thank, or his marriage breakdown to thank, for the fact that we now have a case that says, how do you figure out where gifts and inheritances, or when they're received? Because the argument was made in that case that he was, Monty was a beneficiary under his parents' and his grandparents' wills, and they had all these wonderful shares of companies set up for him. He was worth a lot. And he tried to argue that because by the time his marriage had broken down, he hadn't received any of it yet, then, he received it, the trusts were established already by the time he got married, but he didn't receive anything in his hands until after the date of marriage. So he tried to argue that everything he got was an inheritance acquired or received during marriage, and therefore should be excluded. And the court said, phooey on that. And that was the end of that. Now, the rule now is, if you have an interest in a trust that has already arisen when you got married, then you value it as an asset that you owned at the date of marriage, and the fact that you actually receive, it comes into possession later on, doesn't give you the right to take that as a deduction. One of the issues that they were probably concerned about was the idea of double dipping. If you have an interest in a trust at the date of marriage, why should you get to deduct the value of that in calculating your net family property, and then later on say, okay, now I've got this asset I've received, I'm going to just exclude it from my calculation. But there are other double dipping problems in the family law act that time doesn't obviously permit me to go into. Who can make the equalization claims on behalf of a spouse? Well, remember, equalization claims on death are two parts. One is the election, and the other one is making the actual application. As far as the election is concerned, anybody can make it on your behalf while you're living. Nobody can make it after you're dead. As far as the application itself is concerned, assuming the election has been validly made on your behalf, anybody can make it after your death. When I say anybody, I mean somebody with authority to represent your interests, executors and the like. Revocation of elections, you can't do them. At least you can't revoke elections that have been made in favor of equalization afterwards, and the court has no jurisdiction to overturn it. So if you're advising a client, you better be very careful before you tell them to go ahead and elect in favor of equalization. And I think in the bar admission course materials, there's probably a solicitor's checklist that you can look to see the kind of things that you should go through for that. The most recent decision was this Reed and Reed Martin one that answered a question that amazingly nobody had, no judge had yet answered, and that is, what if you elect in favor of equalization? What does it do to your right to be the executor? And you'll see at the bottom of page 11, section 6 sub 8, that says what happens, what's the impact of an election, and the italicized words, and the will shall be interpreted as if the surviving spouse had died before the other. Certainly raised the question, well, all right, if it says I name my wife Mary, and she elects in favor of equalization, I have to treat the will as if she predeceased. But there is a contrary argument if you look at the Succession Law Reform Act wording that very clearly says in the case of a divorce, the ex-spouse is deemed to have revoked, I think that's the wording, his or her entitlement to be the executor. And the argument is made, well, that language isn't in the other one, isn't in the Family Law Act. Why isn't it there? Because they didn't intend that to be revoked. Anyway, the court said, plain reading, that's all. You don't get to be the executor after you elect, which raises lots of issues that I'm not going to go into. I'm going to let you read the paper, but there are drafting considerations that come up, and that is you're in a conflict of interest as the surviving spouse until you elect, and there's a suggested form of wording to try and get around that problem of the surviving spouse is wearing too many hats on page 13 that you can have a look at. The bigger problem I see is how do you preserve the spouse's right? You don't want them to get both the gifts under the will and the equalization claim. That's kind of an unusual scenario. If you want the surviving spouse to forfeit the gifts if they elect in favor of equalization, how can you retain them to be a trustee for the kids, which is perhaps not an unreasonable scenario? And the answer is, in my view, very cockamamie drafting. Because of the way the Act itself was drafted, and I won't go into it here, but you can see on page 15, or 14 and 15, an example of how I suggest you can draft around it, but it's very painful, and if you showed it to your client, they would say you were crazy. But anyway, that's for what it's worth. Severance of the joint tenancy, if you are a spouse and on your death, you were a joint owner with some other people, not your spouse, of a piece of property that qualifies as a matrimonial home. The Act says it's deemed to have been severed, and there was a little bit of litigation that it took to the Court of Appeal to decide that means just what it says. The problem is, in a lot of situations, first of all, the severance happens whether there's any election in favor of equalization or not. It's got nothing to do with that. And how do you get around that where husband and wife have a city home, the wife has a fractional interest in the cottage property along with a bunch of other siblings that was left to her perhaps by a parent. You're going to get that deemed severance. How do you get out of it? And it's not clear that you can draft a marriage contract, or at least it's not easy to draft a marriage contract to get out of it, because the Family Law Act says any domestic contract that purports to limit a spouse's possessory rights in a matrimonial home is unenforceable. So it's not clear that the spouses could sit down and say, we agree that this property will not be deemed to be severed because that would interfere with the possessory rights of the surviving spouse. But there is actually a very easy way to do it, and that is if you designate one property as a matrimonial home, it results in all other properties not being that way. So in my example, if the parties just jointly agreed the city home was a matrimonial home, then the country home or cottage would cease to be one. Filing an election doesn't represent notice to anybody. So if you're acting for the spouse and who's filing the election, don't stop there. If you want to make sure that property isn't distributed, please make sure you make the application and serve that notice of that application on the surviving spouse if you want to interfere with things. Well, I'm not saying that's everything we know, but that's a lot of the main things we know. What we don't know, and may never, as I said, is an RRSP or a RIF a similar plan? There's this credit mechanism that says if you elect in favor of equalization, certain insurance money has to be credited against the equalization claim, as do lump sum amounts payable under a pension or similar plan. And that raises the question of whether an RRSP is a pension or similar plan. And there's, to my knowledge, no cases that decide that one way or another. But if the RRSP happens to be an insurance contract, then it doesn't matter because it definitely has to be credited because the life insurance of the life insurance credit requirement. Problem with the credit mechanism, especially for RRSPs and RIFs, is how come if you've got $100,000 of life insurance that you receive from your spouse against whose estate you're making equalization, and you've got $100,000 of RRSP, one's pre-tax dollars and one's non-tax dollars, how come you should have to credit dollar for dollar either amount against your equalization claim? There's no cases on it, and there may never be, but it is an issue that the Act wasn't well crafted on that count along with others. I'm going to skip over number 3, talk about the net family property freeze. Have any of you ever heard of this thing, net family property freeze? Nobody? Oh. How about a state freeze? Yeah? And the idea, you want to put a cap on your liability. When you do a state freeze, you say, okay, I got all these one way. I got all this property that's going to go up in value. I'm going to fix it so it doesn't go up anymore, and I'm going to hand over the future growth to the next generation. But if you do, in conjunction with that, if you take advantage, some would say undue advantage of the gifts and inheritances, you say rather than have the children subscribe for new shares with their own money, you have a parent give them the cash and they subscribe for the shares. The argument is, okay, all the future growth is traceable back to a gift of $1. And again, I haven't seen a single case yet where that was done and it was at issue whether that is a scheme that works. And it really depends on how the judge, when confronting that situation, is going to look at that exercise. Is it scandalous? Is it an abuse of the object and spirit of the legislation? Probably. But bear in mind, it's not a taxing statute, and family law judges are a lot more adventuresome, creative, and they don't have any problem in striking down perfectly legitimate transactions if they don't like why they were implemented. And that Harry and Harry case is just a good example of how they'll ignore things if they don't want to. Valuing a policy of insurance one day before death. You've got $1 million of term insurance on your life one day before death. You're not entitled to any of it. Is that part of your calculation of net family property? And the knee-jerk reaction might be no, because one day before death, it's not an asset that you have. There's no cases I'm aware of in Ontario, but there is one in Saskatchewan that I go into in some detail that talks about all these things you can do with that right. You know, change the beneficiary designation irrevocably. How much would somebody pay me to be named irrevocably as the beneficiary? And then there are the so-called viatical settlements where insurance companies will pay money in anticipation that they're going to be paying very soon anyway because the person who is insured has a terminal condition. That term viatical is very interesting. It's kind of a poetically chosen. It means relating to a journey, for your interest. I looked that up right after I counted to 5,000. But that Saskatchewan case says it does have value for that very reason, because you can do things with the policy. And in that case, he was terminally ill, and they attributed half the value of that policy to him. I think I'm almost out of time, right? Oh, good. I'm going to let you read most of the rest of the paper. I'll just mention the charter challenge issue. And that is, right now we have, in terms of property rights, it's only legal spouses. You know that the legislation was changed grudgingly by the Ontario government to put same-sex partners on the same footing as common law spouses, so that dealt with support and all the other things in various statutes. So I was interested to see, they rushed it through, as you know, in like 72 hours. It's very interesting to note that even though they rushed it through the legislature, the coming into force date was November the 20th, the very last date that they had to implement it in order for the M&H decision not to take effect. But the definition of spouse includes this phrase, same-sex partners are in a relationship of some permanence if they are together the natural parents of a child. Now you may think that was a mistake, but it really wasn't. In the National Post a couple of weeks ago, there was an article about two people who were having a lot of trouble conceiving a child, and then it occurred to them, as the reporter said, they were both men. So they got this idea to mix their sperm together. They found a woman's eggs and another woman's womb, and put it all together, and they went to court, according to the report, in California, of course. And they got an order entitling them to the two men to be registered as the father of these twins, in fact, that were going to be born, and no mentioning of the mother. So maybe the legislation was just forward thinking. Anyway, I'm out of time. I'll leave you to read the rest of the paper. Whoop.
Barry always comes up with these zingers. Well, we have 20 minutes, thanks to Barry's quick read there. 20 minutes, if you would come back at 3:15, and we'll continue on with the afternoon program.